Okay, well, good evening, everyone, and welcome to this seminar on the Corporate Insolvency and Governance Act. In July of this year, Quadrant Chambers held a seminar on what was then new law. It's now becoming embedded in our insolvency regime, and the previous speakers thought it would be a good idea to revisit the topic. So I'm delighted to welcome all three of them back. They'll need no introduction to those who did join us in July, but for the benefit of newcomers, Jeremy Richmond, QC, Quadrant's most recent addition to its team of commercial silks, Nicola Alsop, one of Chambers' insolvency experts, though she does other things too, and Emily Saunderson, who brings her experience of fraud, banking, as well as insolvency to the topic. Nicola's going to do a short update on the case law that's arisen since the Act came in. Jeremy's going to do the same, but with a focus on the new restructuring plan. And Emily is going to talk to us about the Ipso facto clause provisions. And those are going to be quite short talks because in what we hope will be an interesting departure from last time, we're then going to look at a case study which our three speakers will discuss from three different points of view, in which we hope will illuminate some practical aspects of the legislation. So I'm now going to ask you to turn off your screens and microphones and to hold any points or questions until the end, to put them on the chat device that you'll find as part of this system. So now I'm going to turn my microphone off, hand you over to the first speaker, and leave her to address what I know is a discomforting void.
Thank you, Stephen. I'm going to speak, as Stephen has said, just briefly to update you as to what's happened since we first spoke in July. Not much has happened by way of case law, although Jeremy has got some cases to mention when we come to his talk. But when we first spoke about CIGA in July, we mentioned that there were various temporary measures which were then going to be enforced until the end of September this year, but with the right of the Secretary of State to extend such temporary measures for a further 6 months. Well, shortly before the temporary measures were due to expire in September of this year, the Secretary of State did indeed exercise the power to extend, and in particular, 3 temporary measures have been extended. Those are listed on the slide there. First of all, statutory demands and winding up petitions. The outright prohibition on serving statutory demands continues. So no winding up petition may be presented on the basis of an unsatisfied stat demand, where that statutory demand was served between the 1st of March this year and now the 31st of December this year. And as we said at the first talk, this is an absolute prohibition. There's no carve out, unlike the position in relation to winding up petitions, in respect of debtor companies unaffected by coronavirus. So the position remains that there's no point in serving a stat demand, although a well-worded pre-action letter will work just as well, or better. In relation to winding up petitions, a creditor may not present a debt-based winding up petition between the 27th of April and now the 31st of December this year, and the court will not make a winding up order unless the coronavirus test is satisfied. Well, the coronavirus test requires at the presentation stage that the creditor says it has reasonable grounds for believing that coronavirus has not had a financial effect on the company, or the company would be unable to pay its debts even if coronavirus had not had that financial effect. Then at the hearing of the winding up petition, the court will not make a winding up order unless it's satisfied that the ground relied upon in the petition, so for example, that the company is unable to pay its debts, would apply even if coronavirus had not had a financial effect on the company. So those are the restrictions in relation to stat demands and winding up petitions, which will now continue until the 31st of December. Secondly, the relaxation of certain conditions for obtaining a moratorium have been extended for the full 6 months, and so until the 30th of March 2021. those restrictions would mean, if there had been no relaxation, that a company that had been subject to an insolvency procedure or a moratorium within the previous 12 months would not be eligible for obtaining a further moratorium. However, that restriction doesn't apply, at least until the 30th of March 2021. The third extension is in relation to the temporary exclusion for small suppliers exercising ipso facto rights. We're going to talk Emily's going to talk in a moment about rights to terminate and the impact that CIGA has had on rights to terminate in the event a counterparty goes into insolvency. So I won't say too much about that now. All I will say is that small suppliers are exempt from those restrictions, and that exemption has been extended until the 30th of March next year. Curiously, perhaps, and this is the final bullet point on this slide, there is no extension in relation to the wrongful trading suspension. Now, this means, in theory at least, that directors of insolvent companies are back on the hook in the event that they allow their companies to continue to trade whilst insolvent, even if that insolvency has been caused by the pandemic. So a strange omission, perhaps. Thank you. I'm going to hand over to Jeremy now, who's going to speak about restructuring plans under CIGA.
Thanks, Nicola. Thanks very much. Before the 2020 Act came into force, there were three paradigmatic ways for a company to restructure its debt. All three will be well known to you, I suspect. The first was a company voluntary arrangement, or CVA. The second was a scheme of arrangement. Important to note that a scheme of arrangement under Part 26 of the Companies Act could be either done by a solvent company or an insolvent company. And thirdly, a pre-pack administration, which has now become a well-known, if not notorious, way of restructuring insolvent company debt. The new restructuring plan is a new beast that was introduced in June when the 2020 Act came into force. In very simple terms, it's, in my view, a more agile form of the scheme of arrangement. It's a complicated statutory schema, which I can't begin to summarize in today's very short talk. But the provisions are set out in Part 26A of the Companies Act, and a very clear practice statement of the scheme of arrangements under Part 26, which was issued shortly after the Act came into force. If I can turn to the next slide briefly. There are three or four major differences between the scheme of arrangement and this new restructuring plan. The first point to note is that the new restructuring plan is necessarily an insolvent restructuring. So unlike the scheme of arrangement, it has to be with a company which is insolvent. And the threshold test is set out at section 901A of the Companies Act. A company has encountered or is likely to encounter financial difficulties that are affecting or will or may affect its ability to carry on business as a going concern. The second point of significant difference with the scheme of arrangement is that for each class of creditor, there has to be approval of 75% of those creditors present and voting either in person or proxy. Under the scheme of arrangement, it had to be both a 75% in value majority as well as a numerical majority. The numerical majority isn't relevant for the restructuring plan. Perhaps most significantly, and thirdly, is what is called a cross-class cram-down. Now, for those of you who are familiar with Chapter 11 insolvencies in the United States, or the new EU restructuring directive, which for obvious reasons isn't going to be implemented in Britain as we have exited the EU, and what it does in simple terms is it can force certain classes of creditors to lose their rights, even if they dissent. Now, because that's such a radical power, there are two conditions for the court has to be satisfied on before the cross-class cram-down can occur. The first is that an other class, which would receive a benefit under the relevant alternative to the plan, and that means what would be likely if the plan were not sanctioned, has voted in favour of the plan. So a class, in simple terms, that has an interest in voting for the plan votes for the plan. So that's the first condition. And it only be one class. So there's 10 classes of creditor. If only one class of creditor agrees to the plan, that's enough to trigger the jurisdiction for cross-class cram down. And the second point is a protective condition that members of the dissenting class, so the classes that don't agree to the plan, will not be worse off under the plan than they would be if the plan were not sanctioned. Turning to the next slide briefly. Unlike other provisions under the 2020 Act, there has been some case law in this area since the legislation was passed in June. The highest profile was Virgin Atlantic, which, because of the turndown in its business in the summer because of COVID, had to carry out an urgent restructuring of its debt. The much anticipated addressing of some of the interesting issues in the restructuring plan didn't really come to pass because of the 4 classes of creditors who were asked to vote. 3 of them voted unanimously for the restructuring plan, and the rump group, the 4th class of creditor, trade creditors, voted to 99.2% in favour. So there was no prospect of a cram down the cram down jurisdiction being engaged in the Virgin restructuring. 2 interesting points. Firstly, in the hearing in which the class of creditors meeting was convened in the summer in August, Mr. Justice Trower expressly affirmed that the principles that apply to the scheme of arrangement would also apply for the new restructuring plan. And then Mr. Justice Snowden, when considering whether to sanction the scheme in September, I believe, this year, in the second of the 2 citations there, essentially approved the scheme on the basis that all class of creditors agreed to it and it met all of the usual criteria for schemes of arrangement. Now, one interesting point is that Mr. Justice Trower did say, however, that because the class cram down jurisdiction is triggered when only one class of creditor agrees to the plan, he would be particularly wary to debtor companies that arrive at court with a class of creditor who already pre-agreed to the plan, particularly if it's unanimous agreement, because depending on how one manipulates the categorization of creditors, that could easily be abused to bring in the court's jurisdiction for cross-class cram down, and that would not be good. So Mr. Justice Trower reserved his position as to what he would do in the future if that were to occur. Very finally, or penultimately rather, Nordic Aviation Capital was an Irish case that was handed down in the 21st of July. I only mention it because for those of you who are in the aviation business, there was an interesting discussion towards the tail end of that case as to whether or not a scheme of arrangement in Ireland, which is similar to a scheme of arrangement in England, was such that it would essentially not affect aviation liens. The issue under Article 1110, or Alternative B to the Cape Town Convention, is that if the scheme of arrangement is considered to be an insolvency proceeding or an insolvency related event, then it cannot bite per se upon aviation liens. So if you're an operator lessor, or in the aviation business, you can comfortably sit on your hands and not be crammed down and affected by a scheme of arrangement. That's of particular importance in the aviation business because Malaysian Airlines, for instance, who were proposing a restructuring plan in the autumn of this year, as far as I'm aware, didn't proceed with it as planned because there were a number of creditors who were intimated that they were standing on their rights in aviation liens. So that can be a trump card for some operator lessors who are owed significant sums by the debtor airline. And I think now it's over to Emily.
Thank you very much, Jeremy. So as I'm sure everybody's aware, one of the key changes that was introduced into the Insolvency Act by CIGA in June, and with the provisions that interfere with a party's contractual right to terminate a contract when there's an insolvency of a counterparty. These are the so-called Ipso facto provisions in the Insolvency Act. And we're going to, as Stephen said at the outset, we're going to look at some case studies in a short while to consider how these provisions work in practice and the sort of problems that they might give rise to. But before we get to that, just so we're all starting on the same page, I'm going to just talk very quickly through the basics of these ipso facto clauses, so we're all starting from a level playing field. Now, I know firstly that Jeremy covered this very well in great detail in our first seminar, so I promise, if you saw that, I'm going to be very brief. I'm not going to tread over old ground and repeat exactly what Jeremy said. So the first thing you need to know about ipso facto clauses is that they only apply to contracts for the supply of goods and services. So if you have a totally different sort of contract, you don't need to worry about these provisions at all. Now, the key provisions are brought in section 233B of the Insolvency Act. And in my opinion, the key provision is subsection 3. And subsection 3 of section 233B says, a provision of a contract for the supply of goods and services to a company ceases to have effect when the company becomes subject to the relevant insolvency procedure, if and to the extent that under that provision, the contract or supply would terminate or any other thing would take place because the company becomes subject to that insolvency procedure, or the supplier would be entitled to terminate the contract or supply or do any other thing because the company becomes subject to that insolvency procedure. So effectively, these provisions are interfering with the supplier's contractual right to terminate a supply or supply of goods and services contract if its counterparty enters into an insolvency process. So perhaps the first question is, well, what is a relevant insolvency procedure under the Act? And it's the usual suspects. It's very much as you would expect. It's a moratorium under Part A1, so the new moratorium procedure, an administration. If an administrative receiver is appointed, that also counts. A CVA, as you'd expect, liquidation, or if there's a convening order in relation to a restructuring plan, that counts as a relevant insolvency process. So what does this all mean for suppliers? Well, I said pros and cons. My view is it's mostly cons. First downside, a supplier can't insist, if it's already owed money by the counterparty, it can't insist on payment of outstanding sums as a condition of continuing to supply once the insolvency process has started. That's specifically outlawed by subsection 7. Another downside is that if you as a supplier had a right to terminate the contract before your counterparty entered into an insolvency procedure, once that insolvency procedure has started, you can't use those circumstances to terminate the contract. It's a use it or lose it provision. If you haven't terminated by the time the insolvency procedure starts, that's it. You can't do it while this insolvency procedure is ongoing. Slight ray of sunshine. If a default occurs during the insolvency procedure, and that default gives right to arise to terminate, there's nothing in these new provisions that stops you as the supplier terminating. So you still have a right to terminate, but it has to be an event that occurs during the insolvency procedure, and it's not because the company is subject to the insolvency procedure. Now, there are some important exceptions that you need to know about. As Nicola mentioned, the first one is this temporary exclusion for small suppliers. So if you were a small supplier and your counterparty entered into an insolvency procedure, these provisions don't apply to you. And this is temporary, and it runs up until, as Nicola said, the 30th of March next year. It's been extended by the recent regulation. So what do you have to do to qualify as a small supplier? Well, it's covered by section 15 of CIGA. And you need to bring yourself within at least 2 of the following conditions. You need, in your most recent financial year, turnover of not more than 10.2 million, balance sheet assets of no more than 5.1 million, and no more than 50 employees. There are also a large number of excluded counterparties, and these are all set out in great detail in Schedule 4ZZA. The number of letters there is immediately disheartening. But anyway, it's 4ZZA, which is inserted by Schedule 12 of CIGA. And it's financial counterparties. Again, what you'd expect: insurance companies, banks, electronic money institutions, payment services providers, other financial services type companies. And then there are a large category of excluded types of contract. Again, you need to look at Schedule 4ZZA, because it's quite specific. And these sorts of contracts include loans, commodities contracts, derivative contracts, and contracts covered by certain master agreements. So if you're a supplier who's gone into if you're a supplier to a company that has entered into one of these insolvency processes, what are your options? Well, you still can terminate. There are 3 ways that can happen. If the office holder consents, if it's the sort of insolvency process that has an office holder, like a liquidation or an administration. So if you get the consent of the office holder, you can terminate. In another case, like a moratorium where the directors stay in charge, you can terminate if the company consents. You can also make an application to court to get the court or to ask the court permission to terminate the contract. Now, the court will need to be satisfied that there is supplier hardship, and there's no definition of supplier hardship in the Act. So you're going to have to think about what will persuade the court that you as a supplier are suffering financial hardship. It might be some sort of cash flow reason if the counterparty hasn't paid you for a long time, you're still having to supply, and they're on long payment terms, for example. You're going to have to work hard to think about, from a common sense perspective, what counts as supplier hardship. And the other silver lining is that the office holder should, if you are continuing to make supplies under the contract, should be ensuring that the supplies are treated as expenses of the insolvency, so they rank ahead of floating charge claims and unsecured debt. So with that quick summary and reminder on what the Ipso facto provisions actually do and what they are, and we're going to go through some case studies now, and I am going to hand over to Stephen, who's going to kindly introduce the first case study.
Right. Thank you very much to all our speakers. Let's see how some at least of that might have an effect in the real world of Neil's Nibbles and Bert's Bars Limited. Bert's Bars operates 5 pubs in London, and Neil supplies crisps and nuts under a 3-year supply contract going back to the 1st of November 2018. The contracts say that Neil may terminate if Bert enters into an insolvency, which includes any insolvency process further to the Insolvency Act. Bert's Bars closed its pubs during the national lockdown in March 2020, and Neil's and Bert agree a temporary suspension of Neil's supply under the contract. Pubs reopen in July and normal supply resumes, but Bert's payments fall behind. Bert entered a moratorium under the Insolvency Act, Part A1, last week. And the question that I'm going to hand to Nicola and Emily to debate, 2 questions. What are Neil's supply obligations in the light of the legislation we've been looking at? And can Neil's Nibbles terminate the contract? You first, I think, Nicola.
Yes, so I'm going to make my arguments on behalf of NN. And first of all, I'm going to address the question as to NN's supply obligations in light of CIGA. Really useful starting point when one comes to consider a case under CIGA is to scrutinise the terms of the contracts, not only to check that the parties, being the supplier and the company, are also the parties to whom the relevant insolvency procedure has occurred, but in particular to ascertain what the particular supply obligations under that contract are. Now, this is a contract for the supply of goods, so I will reluctantly accept on behalf of NN that the restrictions on termination imposed by CIGA are capable of applying. However, it seems to me, based on this case study, that this is not a contract pursuant to which NN is under a continuing obligation to supply. The restrictions only affect supply contracts under which there is a continuing obligation, and this seems to be a 3-year umbrella contract. Perhaps it's one of those contracts that contains terms and conditions, and each order placed by BB is in fact an offer by BB to contract on the terms and conditions which are contained in the 3-year umbrella contract. That means that NN is at liberty to decline the offer and not supply, and it's entitled to do that aside from CIGA and with no termination of the contract at all. And so on that basis, if that's what NN wants to do, it can choose to do that, no restriction. That's all right, isn't it, Emily?
Well, as you said, it so much depends on the terms of the contract. The way I read this problem, it's not an umbrella contract. It doesn't say it's an umbrella contract. It's a straightforward supply contract. This is the paradigm example of the type of supply of goods and services contract that is caught by Section 233B of the Insolvency Act. And unfortunately, you just have to continue to supply. I don't think you've got a leg to stand on here. If it's a sort of contract that says you will supply me X number of bags of nuts every month, how are you going to avoid an obligation to continue to supply?
Well, that moves on to the second question. Can NN terminate the contract? Yes. NN doesn't have to rely on the contractual termination provisions. It can simply rely on its common law right to terminate following an anticipatory breach of contract. Now, let me just be clear about that, because I can see you frowning. BB going into a moratorium or other insolvency procedure is not of itself a repudiatory breach of contract, and I'm not seeking to argue that. However, we can see from this example that BB has a history of failing to pay. Even when the pubs reopened, BB's payments fell quickly behind. Well, that, to my mind, evinces an intention not to abide by the terms of the contract. NN is entitled to conclude that BB is not going to fulfill its contractual obligations. That's an anticipatory breach. NN can accept the renunciation and treat itself as being discharged from further performance, and NN can therefore terminate the contract without any reliance on the ipso facto provision. And before, by way of final point, I reminded myself as you were going through your excellent slides about the specific wording of subsection 3 in 233B, which provides a provision of a contract for the supply of goods and services, etc., cannot be relied upon. I don't need to rely on a provision of a contract.
Interesting, Nicola, interesting. So I'm entering into a moratorium whereby the monitor is representing, and we as the directors of the company are representing, that we believe we can continue as a going concern. And you're telling me that that's an anticipatory breach in terms of this supply agreement. That seems, with, you know, best will in the world, that seems slightly optimistic. We're not saying by entering into this moratorium that we don't intend to pay. We're not putting forward any kind of action that could lead a reasonable person to suppose that we are not intending to pay. This isn't an anticipatory breach. What you seem to be doing is making a very thinly veiled attempt to circumvent the use it or lose it provision, I'm afraid. And I don't think that if this went to court, the judge would have any difficulty seeing through your attempt. In any event, I would say that NN's position is protected, because if it turns out that we can't pay as we go forward in this insolvency procedure, in this moratorium, the monitor should bring the moratorium to an end. And any money that we owe you as a result of this moratorium period will be a debt that's protected. It will rank ahead of the floating charge holders and any unsecured creditors in any subsequent liquidation. So your position, actually, I don't see why you're so desperate to get out of this contract. You're doing your civic duty by continuing to supply here. You're helping the economy.
Well, maybe in this instance, it might be better to contact you and seek a commercial resolution. If you still want my nuts and crisps going forward, then I can see I will be in a better position by reason of supplying you post-moratorium. What about a retention of title over the crisps and nuts I've already sold you that you haven't paid for? Does anyone know what the best before date is?
I'm sure we've already eaten all those, I'm afraid. But in any event, I think that in a moratorium, you can't rely on those sorts of provisions while the moratorium is in place.
It really is very unfair. Thank you. Can I refer back to Stephen, who's now going to move on to a variation to the case study? Thank you.
Thank you very much for that. I think we're getting on to next scenario. There it is up on the screen. Yield supplies to several Baister brewery companies, group companies, including Baister's itself under an umbrella agreement. So we know that this time. The contract provides that Yields may terminate any company in the Baister group enters an insolvency process. A Baister Group company Niels has no dealings with enters administration. Niels is in financial difficulties and wants to get out of the Baister contract. What are its options? And to discuss this, Jeremy is going to open and Emily, I think, is going to oppose.
I think I'm going to actually defer to my learned junior Miss Allsop to make my submissions on my behalf on this occasion.
Ah, right. I've got that wrong.
Excellent. I should say that Jeremy hasn't thrown me under the bus. I was supposed to be answering this. In terms of NN's options, my submission, they're straightforward. NN can terminate the contract relying upon the termination provision contained in the contract. The termination provision is not affected by CIGA because the company that NN supplies is not the company that is subject to the insolvency procedure. And on a straightforward reading of section 233B subsection 3, it must be the same company. And I say that because that section provides a provision of a contract for the supply of goods or services to the company ceases to have effect when the company becomes subject to the relevant insolvency procedure. And if we look at the example here, it's a Baister Group company that NN has no dealings with, which enters administration. So in conjunction with that fact and that subsection, there's no restriction on me exercising my termination clause. And the termination provision provides that I can terminate if any company in the Baister Group enters an insolvency process. And so for that reason, I say, fine, I can go ahead. I'm sure Emily's going to disagree.
Of course I'm going to disagree. I feel on slightly more shaky ground with this one, but that is not stopping me from disagreeing here. I think what BB and Baister Brewery Group would have to say about this is that you are reading that provision too narrowly. There isn't a definition of the company in subsection 3 of section 233B of the Insolvency Act. And in fact, subsection 1 refers to a company becoming subject to the relevant insolvency process. We'd have to say that a narrow reading of that provision would enable Niels to defeat the purpose or the policy of CIGA and the changes it's made to the Insolvency Act, because the whole point is, insofar as possible, to enable companies that are viable to continue trading during these trying times. So we'd say, firstly, it's contrary to the underlying policy of the Act, if you read that clause too narrowly. Secondly, I think we could also say, with justification, that NN's position would lead to the odd result in this particular case, that NN could not terminate if the parent company entered an insolvency process, but it could terminate if a subsidiary of the parent company that had nothing to do with NN did enter an insolvency process. And surely the Act shouldn't be read in a way that would lead to such odd, inconsistent results. So I think that is the way that BB and its parent would have to argue that one.
Briefly, by way of reply, if I may, the reference in a company in subsection 1 doesn't save you, because if you're right, then there would be no limit on the scope of section 233B. A company would mean any company, and that would surely cover cases where there was no connection whatsoever between the company being supplied and the company that was subject to the insolvency procedure. And so I do say that that's a very unattractive position to adopt. And now back to our next variation, please.
Bert's parent company, Baister Brewery, is a party to the supply agreement between Bert's and Niels. Under that agreement, Baister guarantees Bert's liabilities to Niels, but Bert enters a moratorium. So the question is, can Niels Nibbles recover the sums owed to it by BB from Baister under the guarantee? And this time we have got leading counsel not covering in the background behind his junior. That was my fault. We have Jeremy to deal with the proposition proposed, I think, by Emily this time.
Thank you, Judge. I'm actually rather surprised the debtor company has even the temerity to ask this question. The answer to the question is, of course I can enforce under the guarantee. If one goes back to the provisions of the statute, and in particular 233B, that provides that any provision of the contract ceases to have effect when a company becomes subject to a relevant insolvency procedure, which I concede, if they provide that a company or supply would terminate or any other thing would take place before the company becomes subject to that insolvency procedure. So the question then becomes whether or not the enforcement of the guarantee is something which isn't any other thing for the purposes of section 233B. Now, I concede that on a literal reading, any other thing literally includes everything and excludes nothing. But of course, Parliament couldn't have meant that. And as we know from Mr. Justice Snowden, the Virgin Atlantic case, explanatory notes are a critical, not always decisive, but critical way of interpreting the statute. What did Parliament intend to do with section 233B3, and what did it mean by any other thing? Well, a cursory look at the explanatory notes make that clear. The mischief which 233B is aimed at is the continuation of supply. And I would submit that the enforcement of a guarantee against the parent has absolutely no effect whatever upon the supply between myself and the insolvent company. So just to enforce the point, where Parliament wants to deal with a guarantee, it does so expressly. So when one looks at the pithily named Schedule 4 ZZA, Part 2, which deals with financial services, and the carve out from financial services from the Ipso facto clause provisions, Parliament does deal expressly with guarantees. If it wanted to deal with guarantees under the rubric of any other thing, it would have said so. It didn't. So I can happily proceed with my enforcement of the guarantee with no worry in the world. I think you probably agree with that compelling argument, don't you, Emily?
Yes, I may as well just go home now. I mean, I don't know how I can stand up. This is what you get when you pay for a self. No, I completely disagree with you, Jeremy. And I'm somewhat surprised by the force with which you put that argument. Firstly, there is no reason at all to read the words in this act in anything but a literal way. Why should you give a narrow construction to the words any other thing? Since when the words are clear, do we have to turn to any explanatory notes to work out the natural meaning of the words? We say any other thing must include a guarantee. So if we can persuade a court that the guarantee wouldn't have been triggered, but for the company coming under a relevant insolvency procedure, I think we should be okay, that the wording is wide enough to cover it. Now, you've mentioned Schedule 4 ZZA, and it's true that it does mention guarantees as an excluded form of contract. Now, that falls under the definition of financial contract, so there may be an argument we can have as to whether all guarantees are excluded thereby. We may also need to have an argument at some stage about whether this actually is a guarantee. Simply calling something a guarantee doesn't mean it's a guarantee. It may be an indemnity. There may be a way to argue around it on that basis. So, as well as your arguments were put, I'm afraid I still think there is scope to wriggle out of this from Buster Brewery's perspective and BB's perspective.
I can only say that any other thing on the literal interpretation leads to such wide and surprising conclusions that it must be rejected, I would submit. If it wasn't any other thing to do something relatively innocuous on the event of an insolvency, on the event of insolvency of a counterparty, would that contractual term cease to have effect? That just can't be right. The punishment must fit the crime, so to speak. And the Parliament clearly intended a purposive reading of an otherwise absurdly wide provision. I think that moves us on to variation 3 and the last problem we have to debate. Stephen, can I ask you to be so kind?
Here we go, yes. Just a moment, that's right. Yes, the day before BB enters into moratorium, BB and its parent under commercial pressure from MN to a deed of variation to the supplier contract that seeks to contract out of the statutory regime. And we've got the clause there. BB and Buster Brewery irrevocably agree not to rule on any provision of Section 2(3)(b) of the Act in respect of any proceeding, action or step that then commences or takes, or may commence or take, arising from BB entering into any form of insolvency regime under the Act. Right. Jeremy, I think if I've got it right, you're dealing with this as well, aren't you?
I am indeed, and I have to confess, Judge, I have some skin in the game because I am the draft person of this clause. Unsurprisingly, my strong view is this clause works. I'm happy to concede that if this clause was entered into the day after the moratorium, it would fall foul of the provisions of CIGA, and particularly Section 233(b)(7, that says that a supplier cannot insist upon payment of outstanding charges as a condition for continuing to supply once the company enters into a relevant insolvency procedure. So I suspect I'd be sailing too close to the wind if this was entered into the day after the moratorium. But happily for me, on this fact pattern, the agreement was entered into the day before the moratorium. There's no suggestion of duress. There's no suggestion of my client and the supplier being sharp. But more importantly, when Parliament wants to make it clear that parties cannot contract out of a provision, it usually says so, such as the Consumer Protection Act, UCTA, and so on and so forth. And one will look in vain in CIGA for a provision that actually stops parties from contracting out. I would submit also that this would be consistent with the traditional view taken by English Chancery and commercial lawyers that parties can do what they please. It's an instance of freedom of contract, and I rely upon that principle to seek to stop my learned friend Emily's clients from seeking to rely upon CIGA. Emily, agrees?
I've got quite a lot to say about that, actually. As a matter of public policy, you should not be able to contract out of these ipso facto provisions. If you could, that would defeat the very purpose of the provision. It's all about allowing viable companies to trade out of trouble. You can't contract out of that as a matter of public policy. You said the parties, this is a freedom of contract point, the parties should be free to contract as they wish. Again, CIGA, the whole point of the changes introduced by CIGA is that they are limiting the parties' ability to contract in certain situations or to provide for certain situations in their contract. They're limiting contractual rights. And you made a point that there's nothing, you can only contract out of the statute when it says, when there's nothing in the statute to say that to stop you from doing that. I'm not sure that's right. For example, the statute of frauds, I don't think, has any provisions about whether you can contract out of it or not, but it would be surprising if you could contract out of the statute of frauds. And I think that there might actually be some case law. I hate to throw case law in here, but some case law in respect of the Insolvency Act about this. I think there's a case, Court of Appeal decision, Perpetual Trust and BNY Corporate Trustee, that says that you can't contract out of the Insolvency Act, where the effect of that would be to defeat an anti-deprivation rule. There's an older case, not in respect of the Insolvency Act, but the Companies Act of 1948, where the court held, it was British Legal International Air France, the court held that an agreement that had the effect of contracting out of the pari passu principle was contrary to public policy. So it's clear the court will look at this question from a public policy basis. And in my view, we have got the best of the argument on that point. You said economic duress wasn't a goer in this case. I think I'd want to look at that a little bit more closely in terms of the facts. It's worth investigating at least. I wouldn't throw it out entirely. I might want to wait until the Supreme Court's decided the Times Travel and Pakistan Airlines case that they just heard last week before deciding whether that would work or not. But I think it's definitely worth a punt. So yeah, I'm not sure I agree with you, Jeremy, about that one.
Well, I just make 2 points. Statute of frauds, I think it's a 14th century statute, is a little desperate to be pulling out medieval acts of parliament to make good your point. Secondly, perpetual trustees is a case on point, but not for this case. Perpetual trustees deals with the anti-deprivation principle and the divvying up of assets of an insolvent entity to make sure that one creditor doesn't steal the march from another. This is a whole different situation where we're talking about parties' executory obligations to perform under the contract and doesn't bear upon the distribution of assets in insolvency at all. In fact, hopefully for your client, with the help of my client, you'll be able to trade merrily out of the moratorium and into a successful business future. So the anti-deprivation rule won't apply at all. On that somewhat possibly inconclusive note, Stephen, I think we hand over to you for maybe some questions from the audience.
I think you do, Jeremy. I bet if we had a live audience, there'd be plenty to talk about there. I certainly wouldn't fancy giving a judgment on any of those three arguments. But we do have questions. And somebody, Edmund Lowcock, thank you very much for kicking the ball off. Edmund was so enthusiastic, he actually got his in before the conference started. So he deserves a place at the front of the queue. His question's about ipso facto clauses. And what he asks is, Schedule 4ZZA, Part 3 of the Insolvency Act, inserted by Schedule 12, Part 1 of CIGA, provides that financial contracts should be exempt from the provisions of Section 233B. Financial contracts, he says, includes Schedule 4ZZA, he gives the reference, financial leasing, but offers no further explanation as to what constitutes financial leasing for the purposes of exemption. It can perhaps be assumed, he says, that financial leasing includes finance leases, but what are your views as to whether other types of lease, such as operating leases, conditional sales, and hire purchase agreements are caught by the exemption? So, I mean, a lot of detail, but the short end is, what is financial contract, or what is it capable of being? Who wants to start with that?
I don't mind taking that because I did, when the question came in, I had a little look at the provision. So for what it's worth, my view is that financial leasing, as Edmund said, it's not defined, financial leasing, but it comes as part of the definition of financial contract. So I think that there probably has to be some element of extending credit to the counterparty. So I think a straightforward lease of equipment like hiring a photocopier probably isn't enough. But a hire purchase agreement where there is a finance part to the lease would be enough to fall within this exempted list of contracts. I don't know if Jeremy, Nicola, you've got any views on that.
That was my instinct as well before I looked it up and before I thought about it any more. So I'm glad that I agreed with you on instincts. I think that otherwise it would just be a lease, wouldn't it? If there was no aspect of extending credit, then the financial leasing wouldn't mean anything.
I think I agree with that, and I wouldn't be surprised if the government under secondary legislation clarified a point, because it's obviously a big point in the finance leasing market. They need to know when they can and cannot terminate leases for non-payment.
Anything to add on that? It's obviously of some interest because Gemma Murphy put a similar question, not knowing, I think, of Edmund, but I think subject to Gemma coming back, I hope we've done that. Another question I've got was timed at 5:28, so it's obviously all about Berts and Nibbles. Does it make a difference that in this instance nuts are not strictly bracket VAT, as they're not for cooking? I don't know whether anyone knows enough about VAT or indeed about nuts.
I thought that was a brilliant question. It made me smile.
Brilliant question, yes. Nicola, you're obviously dying to answer it.
Well, does this just come down to whether or not it's a good or service for the purpose of the CIGA restrictions? And I would hesitate to gamble that nuts and crisps are a good, even if they're not vatable, and that therefore the contract to supply them is a contract which can be caught by the provisions.
I agree. I strongly agree with that.
Emily, do you want to add anything about nuts, or are you?
I've got no idea.
Okay. Can I ask another one? Nicola, you mentioned the failure to renew the wrongful trading.
Yes, what do you make of that?
And one wonders whether it's just a mess up, it's fallen through the net with conscious. But would it be possible for a director in the or to what extent do you think a director could rely on current exceptional circumstances? Under Section 1157, reasonable and honest.
Yeah, absolutely.
Any thoughts on that?
Yeah, very interesting point. I think it would require the company and its directors to show that it was a temporary problem caused by COVID and that it had a long-term plan or a long-term aim, which it was going to be able to come out of its problems once COVID ended. And so there would need to be some foresight on behalf of the directors. They would have had to have thought about the issue as I see it. But if they could point to a temporary blip, then caused by COVID, I think it would be difficult to get them on wrongful trading. It's very fact specific, isn't it? No, I also thought, sorry, Jeremy, that the court might be a little bit more sympathetic to an honest director during COVID times, given the unprecedented nature of the times we're living in. But I can't speak for certain on that. Sorry, Jeremy, you wanted to.
Yes, sorry, I was going to say, Stephen, that I think actually it was a considered decision by the government not to extend wrongful trading, because it was fought by the creditor lobby and to some extent, I think the consumer lobby, that directors would be given a perverse incentive to trade undercapitalized companies going forward. So I don't think it slipped through the net. But that said, I do agree with you that the honest and reasonable provisions in the Companies Act probably would come to the aid of a director in the COVID world. And also, let's not forget that a wrongful trading provision is very hard to get a home on for a liquidator or an administrator. When one looks at the cases from, I think, 2014 onwards, I know 2008 onwards, I say that because it was one of the last cases I did before I moved chambers wasn't wrongful trading. But if you look at the cases from that time onwards, there's very few cases where people get home because it's quite hard to show there is no real prospect or returning a company to solvency once you reach a point of no return.
Anything to add on that?
Nothing for me.
We're coming up to 5 to 6. We were going to finish fairly promptly, but there's room for one more question, or perhaps even two, if anybody would like to chip in at the end. We dealt with those. I mean, I'd love to have a debate with somebody on the public policy point about that contractual clause. What's the limit of policy? To what extent can one be said to be ousting jurisdictions? It's probably too big a topic, isn't it, for today? So with the last call for questions, to which I don't see a response, I'm going to gradually draw this to a close, thanking all of our speakers for absolutely fascinating run through, particularly the practical problems, which I think you'll all benefit from, if not necessarily knowing the answers. There's a lot there to think about. Thanks also to Sarah Longdon for her work, in getting this seminar organised, and thank you to our many attendees. I think Sarah mentioned just before this started it's being recorded, so I think anyone who's missed it will have an opportunity to catch up at some other stage. But there we go. It's an interesting piece of legislation. It will no doubt develop as the case law goes on. But thank you in the meantime. For the Freudians among you, I think I managed to prove that CIGA is sometimes only a cigar. And on that feeble note and attempt at humour, I'm going to say good night to everyone, and thanks so much for stimulating our.
Thank you for hosting. Thank you.